and I will go ahead and change the host. All right, and this round is good to begin. Thank you.
Sorry, you should be sending me a script I'm supposed to read. It will just be a second. Okay, sorry about that. We just received the message to get started. Let's call the case of the estates of Genesis Petrillo v. Peony Estates and Harper Martini. My name is Judge John Wersgala, scoring judge and presiding judge. The scoring judge, I believe, is Mark Stamen. Please look to the two buttons on the lower left of your screen and remember to keep your audio and video off unless you're told otherwise. You should also have your video set to hide all non-video participants. This meaning the only people on the screen right now should be the advocates and me. Can the attorneys please make their appearances?
Yes, good evening, Your Honor. My name is Joseph Herrera, and I, along with my co-counsel.
Good evening, Your Honor. My name is Avani Soni.
And good evening, Your Honor. My name is Gabriel Hollis.
And today, we represent the plaintiff side in today's case and name of Genesis Petrillo.
Defense, can you introduce yourselves?
Good evening, Your Honor. I'm Andrew Christian, and along with my co-counsel, Mr. Dylan McDowell.
Good afternoon, Your Honor.
Good afternoon.
And Miss Allison Yates.
Good afternoon, Your Honor.
We represent the defendant, Peony Estates Winery, in today's case.
Thank you. Are there any pretrial matters to discuss?
Yes, Your Honor. May we begin by drawing your attention to speculation number 3 that says exhibits 1 through 10 have already been pre-admitted. Both sides have already agreed to this.
Okay, it's noted.
Okay. May we treat you as both judge and jury?
You will treat me just as the judge. You will address the jury as the jury.
Okay. And may we assume that all exhibits have been pre-marked?
Yes.
Okay. May we also invoke Rule 603, which calls for constructive pre-swearing of all witnesses prior to their testimony today?
Yes.
Okay. And may we also invoke Rule 615, calling for constructive sequestration of all witnesses bearing part representatives. It should be noted that neither the defense nor the plaintiff have a party representative in today's case.
The rule is invoked.
Thank you. And can we assume all evidentiary arguments are heard outside the earshot of the jury?
Yes.
Okay. And do you have the court's permission to display demonstrative aids, or do you prefer that we ask every time that we want to bring it up?
If something's been pre-admitted, obviously just note that it's been pre-admitted. If something has not been entered, if something has not already been offered into evidence, request it.
Okay. Your Honor, at this time, I would also like to bring the court's attention to the fact that the defense has already agreed to elements 2 and 4 of the negligence per se case we present today. So therefore, the plaintiff will only have to prove elements 1 and 3.
So the defense is admitted to 2 and 4?
Yes, Your Honor.
Okay. Is that correct, defense?
Yes, Your Honor.
Okay. Anything else from the plaintiff?
Yes, time allowing, may we have a brief recess in the conclusion of the plaintiff's case in chief?
We will have a 5-minute recess at the conclusion of the plaintiff's case in chief and a 5-minute recess at the conclusion of the defendant's case in chief.
Okay, and with that, the plaintiff is ready to proceed.
Defense, do you have any pretrial matters?
Yes, Your Honor. We'd like to know Your Honor's opinion about our position when giving statements, whether we would be standing or sitting.
It's up to you. I have no preference on whether you sit or stand, whatever's comfortable.
All right, thank you, Your Honor. And at this time, the defense is ready to proceed.
Okay. We will now hear opening statements from each party. Everyone should make sure they are in speaker view, the button in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking.
May it please the court. Choices. Ladies and gentlemen of the jury, choices are things that we are all familiar with. We all make choices in every aspect of our lives. Some are inconsequential, like what type of clothes you decide to wear, but other choices, they play a pretty big role in our lives and change the very course of our future, such as who we marry and where we live. These such choices are why we are here today. The story of Genesis and Casey began with a choice. Both Genesis and Casey made the choice to go to a party hosted by a friend, and it was at this party where they fell in love, and they spent several happy years together until on the day of July 18th, 2018, Genesis made the choice to propose to Casey, the love of his life. Following their engagement, they made the choice to hold their wedding at Rosie and Pedro Winery, but that was not to be. Casey's mother, Harper Martini, asked them to reconsider this choice and instead hold their wedding at her own winery, Peony Estates. Ladies and gentlemen of the jury, this is the same Peony Estates we are charging with negligence per se today. And this is the same Peony Estates that has made the choice multiple times, as the evidence will show, to choose convenience over the safety of their own customers. After Casey and Genesis made the choice to relocate their wedding at Peony Estates, they also agreed to hold all of their wedding festivities at Peony Estates. Now, as you may hear throughout the course of the trial today, Peony Estates had previously made several choices that played a role in the events leading up to the reason why we're here today. The happy couple was enjoying their wedding festivities and enjoying time spent with family and friends when on the fateful day of June 7, 2019, Genesis was gifted a bottle of wine that he proceeded to drink from. And it was this choice to drink from the bottle of wine he was gifted at his own wedding that ultimately led to his untimely passing. This choice should not have resulted in the tragic death of Genesis Petrillo. Ladies and gentlemen of the jury, my name is Gabriel Hollis, and I, along with my co-counsel Avani Soni and Joseph Herrera, have the privilege and responsibility of representing the plaintiff in today's case, the estate of Genesis Petrillo against Peony Estates. Myself and my co-counsel, as the plaintiff in today's trial, bear the burden of proof, and this burden of proof is that of preponderance of the evidence, or that the facts of the case are more likely than not true. We are charging the defendant today with negligence per se, which means that they violated an established statute that was there for the health and safety of the general public. To meet this burden, we are going to be bringing forth 3 witnesses, first being Angel Rodriguez, who was a close friend of the happy couple. And through her testimony, you will hear about the events of the wedding rehearsal night as they happened. And second, we will bring forth Inspector Riley Atkins O'Keefe, who was the health inspector who regularly conducted inspections out of Peony Estates, and she will speak of what she has found through the course of her inspections. And lastly, we will bring forth Dr. Kwan, who was the emergency room physician who tended to Genesis in the final moments before he died. Ladies and gentlemen of the jury, let me make this clear. My co-counsel and I stand before you today not to prove Peony Estates guilty in the death of Genesis Petrillo, but rather we are here today to provide the burden of proof necessary to prove Peony Estates should be held liable. We trust that the evidence today will show you that Peony Estates was negligent in both their actions and inactions, which resulted in this tragedy. Choices, ladies and gentlemen. Today, we trust you will make the right choice and find Peony Estates liable in the death of Genesis Petrillo.
Your Honor, may I proceed?
You may.
Your Honor, opposing counsel and members of the jury, may it please the court. Peony Estates was and is committed to safety. Austin Lewis and Harper Martini have been business partners ever since Peony Estates opened. That being said, they have worked tirelessly through each stumbling block that has been presented to them time and time again. Since 2015, Peony Estates has received 3 health code violations. And after each of these violations, the staff of Peony Estates has worked tirelessly to not only fix the issues at hand, but to go above and beyond the issues, to make sure that safety is in the present and in the future. Not only for the safety of their consumers, but also to make sure that the love of Harper Martini's life, Casey Soto, was safe as well. Now, we are here today because a man by the name of Genesis Petrillo died due to respiratory arrest after consuming a bottle of wine produced by Peony Estates. Members of the jury, the plaintiff has the burden of proof in today's round. They must prove to you by a preponderance of the evidence that 1, the defendant violated a statute, 2, the statute was a safety statute, 3, that the violation of the statute caused a direct harm to Genesis Petrillo, and 4, that Genesis Petrillo is a member of the protected class listed under Midland's law. We are not contesting Genesis Petrillo being a member of that protected class, but what we are contesting is that Peony Estates violated any statute listed under Midland's Building Code 10-100. Now, the plaintiff must prove all 4 requirements of this burden, and if they do not, then we will ask you to find Peony Estates not liable. As the defense in today's round, we do not have a burden. We do not have to prove anything to you, but we will nonetheless prove that Peony Estates did not violate any statutes, and we will do so through 3 key witnesses. First, we will be calling Danny Francasio to the stand. Danny Francasio will testify to the development of Harper Martini within the winery industry and to the information that Harper gained while working under Danny Francasio. Mr. Francasio will also testify to the attempts Harper made to maintain safety at Peony Estates, learn safe solutions to the issues at hand, and what Danny Francasio specifically told Harper in order to fix these issues. Second, we'll be calling Dr. R. Cannon. Dr. Cannon will testify to her examination of the analysis of Genesis Petrillo, a potential alternative cause of death, and that the initial examination of Genesis Petrillo was not scientifically conclusive. And finally, we'll be calling Austin Lewis, the head winemaker of Peony Estates. Mr. Lewis will testify to the great lengths that the defendant went to, not only to maintain safety, but to remedy these issues past what was even asked of Peony Estates in the first place, and how Mr. Lewis personally did whatever was asked of him for Peony Estates to remain within regulation. Now, at the end of today's trial, my co-counsel, Dylan McDowell, will come before the court and explain to you the facts of today's case and how the plaintiff was not able to meet all 4 requirements of their burden. He will then ask you to find Peony Estates not liable because Peony Estates was and is committed to safety. Thank you.
Plaintiff, are you ready to proceed by calling your first witness?
Yes, Your Honor. The plaintiff calls Angel Rodriguez to the stand. Ms. Rodriguez?
Yes.
Okay. There we go. Sorry. Please state your name for the record.
My name is Angel Rodriguez.
If I were to show you a picture of Genesis, would you recognize it?
Yes, of course.
Your Honor, permission to display pre-admitted Exhibit 1 for the witness to view.
You may display any pre-admitted exhibits. Just mention them for the purpose of the record as you do it.
Yes. And can you describe what is displayed before you?
Yes, that is Genesis, my very close friend.
And has it been altered in any way since you last saw it?
No, it has not.
When did you first meet Genesis?
Well, we first met in the spring of 2016 through a very mutual friend.
And can you describe your relationship with Genesis and Casey after you met them?
We like I said, we were very close friends that Genesis and Casey got engaged, and they asked me to be part of the wedding party, and I became, of course, involved with the wedding process. And Casey and I, especially up until Genesis' death.
Okay, and what happened after the engagement?
We had everything planned out, from flowers, cake, the table. Everything looked so beautiful. But up until everything changed, Harper asked that the wedding be held at Peony Estates.
Okay, and that's a pretty major change. So what did Casey and Genesis both decide to do after that?
Well, they agreed to hold the wedding and its festivities at Peony Estates, like I said.
And did you come across any pesticides, or excuse me, moving on later to the rehearsal dinner, did you come across any pesticides at Peony Estates?
Well, I saw Harper holding an aerosol container labeled pesticide as they walked the hall and towards the kitchen.
And what happened after the toast later that evening?
Well, Genesis, with the entire wedding party they had produced at Peony Estates, Genesis received a bottle labeled Cara, while the rest of the party received Horizon.
And what did Genesis do with the bottle of wine after receiving it?
Well, they started drinking it, of course. I saw them drink several glasses of wine in a short period of time. But from my experience, this was out of the ordinary for Genesis, though it's hard to say exactly how many glasses he drank.
And did anyone else drink from that bottle of wine that Genesis received?
Yes, only I did, but I didn't like the taste, so I spat it out.
Yeah, and at any point during the night, did you notice anything different about Genesis or his behavior?
Well, it was around 11 at night. Genesis got up and I noticed his body movement, dancing movements were off, and his speech was very slurred.
Objection. Lack of personal knowledge.
May I respond, Your Honor?
Yes.
It is this witness's testimony that she was there the whole night, and she has knowledge of what Genesis was doing because she spent most of the evening with Genesis.
I'm going to overrule the objection. Continue.
And I'll go ahead and repeat my question. At any point during the night, did you notice anything that was different about Genesis or his behavior?
Well, like I said, his dance movements, his speech was slurred. His behavior seemed very disproportionate to the amount of alcohol that I saw him consume.
And what happened in the following hour after that?
It was around midnight and I noticed Genesis was slumped over his chair. I figured I should take him up to his room for the rest of the wedding. It took me roughly about half an hour to get him over to his room. I've never seen Genesis this out of it before.
And I know this may be hard to talk about, but were you concerned for his health at any point?
Yes, by the time we got to Genesis' room, his skin was very flushed and he could not drink water. If he drank it, he spat it out. And the last thing he told me was to dial 911. I immediately called the ambulance and I feel terrible for noticing that anything was sooner, you know?
Yes, and what happened after the ambulance arrived?
If I recall, they arrived around 1 in the morning and I accompanied Genesis to the hospital. I tried to contact Genesis' parents, but nobody responded.
And between the time you took Genesis up to his room and you called 911, did you call Casey or any other member of the wedding party?
Because I thought Genesis would recover, I did not want to put any additional issues on Casey the night before her wedding. I had no way of knowing what would happen.
Yeah, and what happened later that morning?
Around 8 in the morning of the wedding, the doctors informed me that Genesis had slipped into coma and whatever they were suffering was caused some kind of poison.
What did you do after receiving this information?
Well, of course, I immediately went back to the winery. I knew I had to tell Casey and the rest of the wedding party that Genesis had slipped into coma.
And what happened next?
And as I returned to the hospital, I only to find out that Genesis had passed away. That was the most saddest moment of my life.
I passed the witness.
Cross-examination.
Yes. Ms. Rodriguez, were you at the wedding rehearsal on June 7th, 2019?
Yes, that is right.
And you sat next to Genesis during this rehearsal?
That is correct. Yes, the way things were set up. Yes.
You were present during Harper's toast at 10 p.m.?
Yes.
You then witnessed Harper giving wine bottles to members of the wedding party?
Can you repeat the question?
You witnessed Harper Martini giving bottles of wine to members of the wedding party?
Yes, if I recall, yes.
And you specifically observed that Genesis received a bottle of Caro wine?
Yes, that is true.
And the rest of the wedding party received Horizon wine?
That is correct, yes.
You saw Genesis pour a glass of this wine?
Yes.
Genesis then offered you a glass of this wine?
Yes, he did.
You took a sip of this wine?
I did take a sip, yes.
You then spit out that sip, correct?
Yes.
After this, Genesis had finished his first glass of wine?
Yes.
And you then watched Genesis drink several glasses after that?
Yes, I did.
And later that night, around 11 p.m., you noticed that Genesis had slurred speech?
That is correct, yes.
You then noticed that Genesis lacked coordination as well?
Yes.
You then offered to take Genesis upstairs?
Yes, I did.
And you did this because you were concerned for Genesis?
I'm very concerned, yes.
And Genesis told you no?
I don't recall.
Question hearsay.
May I respond, Your Honor? You might be muted, Your Honor.
May respond.
Thank you. So this is within a rational perception, considering that this was a conversation between Ms. Rodriguez and Genesis Petrillo.
Any response, plaintiff?
Yes. I'm trying to think. I'm sorry, no response, Your Honor.
I'm going to overrule the objection.
Yes, Your Honor.
You may continue.
Ms. Rodriguez, did Genesis tell you no after offering the first time to take Genesis upstairs?
If I recall correctly, yes.
And at around 12 p.m., you saw Genesis ordering shots of tequila.
Yes, that is.
Somewhat afterwards, you saw that Genesis had slumped over at the bar.
That is correct, yes.
And at that point in the night, you took Genesis upstairs.
Yes, I did.
And once Genesis was back in his room, he began vomiting.
Yes,
And then proceeded to pass out.
that is correct. Yes, he did pass out.
Thank you, Ms. Rodriguez. I have no further questions, Your Honor.
Any redirect?
No, Your Honor. Permission to dismiss this witness.
The witness may be excused. You may call your next witness.
And just calls Inspector O'Keefe to the stand. May I begin, Your Honor?
Proceed.
Can you say your name for the court?
Yes, hello. My name is Riley Atkins O'Keefe.
And Ms. O'Keefe, what do you do for a living?
I'm a senior inspector for the DHES and the FDA.
And can you describe some of the duties you conduct as a senior health inspector?
Oh, yes, I could do winery inspections. I do restaurant inspections. I just make sure when you bite into a sandwich, everything, all you taste is delicious sandwich and everything is very good.
As of today, how many inspections would you say you've conducted throughout the course of your career?
Oh my goodness, ooh, close to 200, around there.
At any point during your career, did you have to make yourself familiar with any local building or health codes?
Of course, if I don't know these building codes, I can't do my job. I have to know them in order to do my job.
And why is it so important for you to learn these codes?
Well, if I don't know these codes, bad things can happen. Of course, like everyone, again, and I have to do my job. Bad things can, if I don't know these codes, very bad things can happen.
Moving on from that, can you describe the court how you're involved in this case today?
Yes, I did inspections for Peony Estates between the years of 2015 and 2019, where Peony Estates was in violation of a health code.
What health code was that?
It was Midlands Building Code 12-100. It's a health and safety statute. Oh my goodness.
And earlier you had mentioned that you conducted inspections at Peony Estates. Can you talk a little bit about the first inspection you conducted there?
Yes, the first inspection was way back in 2015. There was no, I went in and did everything. There was no violations. Everything looked good, except something did worry me just a little bit.
What was that thing that worried you?
Oh my goodness, I found a can of pesticides outside the kitchen. The can of pesticides had to be 50 feet away from any food surfaces.
Objection, Your Honor. Your Honor, may I be heard?
Yes, state your objection.
Yes, Your Honor. Under Rule 602, the witnesses' statements call for a lack of personal knowledge as to how they know that it was a specific can of pesticides outside of the kitchen.
Response?
Response, Your Honor.
Yes.
Present sense impression, the inspector was there on that day and saw for themselves that the pesticide container was there.
I'm going to overrule the objection. Continue.
After you saw this kind of pesticide, what did you see?
Oh, well, I saw the kind of pesticides and I reminded them that it had to be 50 feet away. And so I told Harper Martini to come here and that this is not a violation, but it's very scary. You have to move it.
I wanted to talk a little bit about something you had mentioned. You kept mentioning 50 feet. Why that specific number?
Well, if it's over there and the food's over here, there's no contamination. So that's why it has to be 50 feet away to ensure there is no cross-contamination.
Aside from that, what you saw about the pesticide, was there anything else you found that day?
No, I just continued on with my inspection. Everything was good other than that.
And after the year 2015, did you ever conduct another inspection at Peonia Estates?
Yes, I did. I believe it was in 2018. And this time I went into the cellar.
Did you find anything in the cellar?
This cellar. I walk in and I just see pests. Very, very gross. They were there for 48 weeks.
Objection, Your Honor.
State your objection.
Your Honor, under Rule 602, again, this calls for a lack of personal knowledge as to how Riley O'Keefe knows how long these specific pests were in the cellar.
Response.
I can lay the proper foundation to establish this fact, Your Honor.
Okay, lay the foundation.
Yes, Your Honor. Inspector O'Keefe, how can you tell that the pests were there for 4 to 8 weeks?
Well, I saw them I saw a lot of dead bodies. If they were new pests there wouldn't be much dead bodies there, right? So I just saw a bunch of dead bodies and I was like, they've been here for a very, very long time.
And moving on, after you saw these pests, what did you do?
Well, I told Harper Martini to come here again. And I was like, listen, this is very gross. You have to spray down pesticide, but I told her that be careful with the pesticides because you have to be careful because you remember you cannot store the pesticides.
Objection, Your Honor.
Proceed.
Your Honor, under Rule 703, this is an improper expert opinion into Riley O'Keefe's knowledge of what pesticides could actually do, as they are not an expert in the field of toxicology or pesticide usage.
Response, Your Honor?
Yes.
As a health inspector, part of their training is going to be about the dangers of pesticides, and as that is something that he is inspecting for, she is aware and knowledgeable at least of the dangerous effects of pesticides.
Your Honor, may I respond?
You may.
Your Honor, if this is the case, then opposing counsel has laid no foundation as to any of the training or expertise that they would have in this field. And again, Your Honor, without that foundation, this is an improper expert opinion as to how they would be able to testify to the usages of pesticides and how that would ultimately affect the pest problem that was apparently had at Peonia Estates.
Response.
Your Honor, as the witness had previously testified to, she has conducted over close to 200 inspections, and she is testifying to this as a rationally based perception.
I'm going to overrule your objection. And for the record, I'm going to overrule the previous objection. Proceed.
Yes, Your Honor. Inspector O'Keefe, what did you do once you noticed all these pests in the cellar?
Well, I told Harper Martini to come here, and I was like, you make sure you spray down this place with the pesticides. But remember that the pesticides cannot be stored in the bottling, the cellar. You have to keep things 50 feet away.
And after this inspection in 2018, did you conduct another inspection at Peonia Estates?
Yes, I did in May of 2019.
Can you talk about this inspection, please?
Oh my goodness, this one gives me a headache. This one, there was 4 major health code violations.
What were these 4 health code violations that you saw?
Oh my goodness, these were all in the bottling area. So the employees, did not know the importance of keeping pesticides 50 feet away. Oh my goodness.
What were the other violations you saw that day?
Another one was that the pesticides, no, they weren't 50 feet, they were 30 feet. They were right in the bottling area. Oh my goodness. And then another one was that there was problems with their drainage system. It was not working properly.
You had said there were 4 violations. What was the 4th violation?
Oh my goodness, this one, I walk in and I see a beautiful bottle of Cara wine, right? I look at it and I was like, I want to sip, right? And then I look over and there is a bottle of pesticides right there.
Objection,
right?
Your Honor.
State the objection.
Objection, Your Honor. Under Rule 602, again, we're calling for a lack of personal knowledge on the grounds that this specific bottle of wine was specifically Cara wine.
Response, Your Honor.
I'm going to overrule the objection. Continue.
Yes, Your Honor. Can you continue speaking about the 4th violation you found, Inspector?
Yes, like I said, I look over and right next to the bottle of Cara wine, I saw a bottle of pesticide right next to it. I was like, oh, no way.
And as a result of these violations, what did you do?
Oh, well, these are big violations. So I have to tell them, I'm sorry, I have to put you on something called probation.
And what does it mean when a winery is put on probation?
It just means in 45 days, I have to come back and do a surprise inspection. And if they pass, okay. If they don't, sorry, I have to shut you down.
Were you ever able to come back and conduct that surprise inspection within the 45 days?
No, because Petrino died.
No further questions at this time, Your Honor. I pass the witness.
Cross.
Yes, Your Honor. Now, Ms. O'Keefe, I'd like to direct your attention to November 5th of 2015. Ms. O'Keefe, you performed an inspection on this day at Peony Estates.
Yes.
And during this inspection, you found pesticides stored in an incorrect location.
Yes.
And you alerted Harper Martini about the incorrect location.
Yes, I did. It was right outside the kitchen.
Right. And then you watched Harper Martini move this bottle of pesticides to a proper location, correct?
Well, I just told her to move it, and she moves it, yes.
So after you watched Harper Martini move this bottle of pesticides, you noticed no other health, safety, or sanitation concerns during your inspection, correct?
No, but again, that one worried me just a little bit. It was right in the kitchen, you know, that's where you eat the food.
Okay. Now, I'd like to direct your attention to July 12th of 2018. Ms. O'Keefe, you performed another inspection at Peony Estates on this day.
Yes, I did.
And during this inspection, you found pests in the cellar.
Yes, I was walking around like this. It was very gross.
So that is my yes to my question. You found pests inside of the cellar.
Yes, I did.
And Ms. O'Keefe, you informed Harper Martini about the presence of pests within the cellar.
Yes, I did.
Now, Ms. O'Keefe, because you found pests within the wine cellar, you decided to perform a lab report on the wine within the cellar.
Yes, I did. Yes, I did. Sorry.
And you would recognize a copy of these lab report results if I were to show them to you today?
Yes.
Your Honor,
Objection, Your Honor.
State the objection.
This lab results were from 2018, and the wine in question was produced and bottled in 2019, so there's really no relevance to the case at hand.
So you have a relevance objection. Response.
Your Honor, this is completely relevant to today's case, as opposing counsel elicited during their direct examination that there was a pest problem in 2018 and that their next previous inspection was on May 8th, 2019, which would be them able to analyze the situation of the pest problem at a future date that is completely relevant to where we are about, because it has complete relevancy to Building Code 12-100, which is being contested in today's case.
Response, Your Honor. In that case, I'd like to also raise an objection to improper.
Okay, go on, sorry. You have another
I'd
objection?
also, yes, Your Honor, to improper character evidence, just because in the past that Inspector O'Keefe might have found one result does not further state that that same result is likely to occur in the case that we are trying at hand today.
I'm going to overrule that objection. Defense, proceed.
Yes, Your Honor. Now, Your Honor, at this time, I'm now approaching opposing counsel with what has previously been marked as Exhibit 9. Your Honor, may I approach the witness?
You may. And you can
Now-
consistently do that.
Yes, Your Honor. Your Honor, is it okay if we screen share the following exhibit for Exhibit 9 to publish to the jury?
Exhibit 9's already been admitted, correct?
Yes, Your Honor. Per stipulation 3, Exhibits 1 through 10 have already been pre-admitted into evidence.
Going forward, if the exhibit's already been admitted, just state what the exhibit is that you're showing for the purposes of the record. You don't have to ask.
Yes, Your Honor. Now, now, Ms. O'Keefe, I have now handed you what has previously been marked as Exhibit 9. Do you recognize Exhibit 9?
I don't see it.
So not on the screen.
No, I don't see it.
Let me see if I can get this fixed. I'm trying to get this situated. I'm sorry.
Okay.
Thank you. Sorry about that. Now, Ms. O'Keefe, I have now handed you what has previously been marked as Exhibit 9. Do you recognize Exhibit 9?
Yes.
And what do you recognize Exhibit 9 to be?
The lab.
And has this lab report been changed or altered in any way?
No.
And is this a fair and accurate representation of the lab report from your inspection on July 12, 2018?
Yes.
Now, I'd like to direct your attention to an area on the lab report noticed as isofenfos.
Okay, yes.
Now, Ms. O'Keefe, you would agree with me that the result of the isofenfos concentration levels was of 45 micrograms per liter, correct?
Yes.
And you would agree with me that the reporting limit under isofenfos is 50 micrograms per liter, correct?
Yes.
So you would agree with me at this time that the Cara wine was within FDA regulations for isofenfos organophosphate?
Yes, it wasn't. It was in regulation. Again, the only thing that worried me from that report was the pest mainly. I didn't feel comfortable from the pest in the cellar that time.
Exactly. This is why you conducted this is why you asked for this very exact lab report.
Yes.
Thank you, Ms. O'Keefe. Now, another issue that you had while at the inspection on July 12, 2018 was a location of a pesticide storage facility.
Yes, I did have an issue with that.
That's right. You felt like the location of this facility was located too far away.
Yes, this is only because the employees sometimes, like, I come and that first inspection. You remember? I come in that first inspection and they had the pesticide laying around. So it was a suggestion basically.
Well, Ms. O'Keefe, I do remember what you were saying, but I'm going to direct you back to my exact question for your inspection on July 12, 2018. You noticed that this pesticide storage facility was located too far away.
Yes, I did. But again, it's because of the pesticides. They had it laying around. So I just suggested.
So that is a yes to my question. The pesticide storage facility was too far away.
Yes.
However, you would agree with me that the pesticide storage facility was located over 50 feet away.
Yes, it was.
In fact, oh, go ahead, Ms. O'Keefe.
But again, the only reason I said that they should do this is because the first inspection they had the pesticides next to the kitchen, and they claim that it was because that basically it was just because it was in the kitchen, near the kitchen, right? So I suggested that they should just make it a little bit closer, so more people, it'll be more convenient for them.
Well, Ms. O'Keefe, I want to talk about the convenience of this, actually. You stated that on July 12, 2018, that the location of this pesticide storage facility was inconvenient.
Objection, Your Honor. This has been asked and answered already multiple times by the witness.
Your Honor, may I respond?
May.
Your Honor, I have not once asked any question regarding the inconvenience of this pesticide storage location. Your Honor, we have heard everything relating back to a previous inspection that was held, and I am now asking about the inconvenience of this pesticide storage location. This is the first time that I've actually asked for the inconvenience of this specific storage facility on this specific date.
I'm going to overrule the objection. Continue.
Now, Ms. O'Keefe, you would agree with me that you believed that this inspection, that this storage facility was inconveniently located.
I'm a little confused. Are you talking about the storage because it's far away?
Yes, you stated that on July 12, 2018, the storage facility for the pesticides was located too inconveniently away.
Yes.
Even though that this location was over the FDA required level of 50 feet.
Yes.
Finally, I'd like to direct your attention to May 8th, 2019. You performed another inspection on this date as well, correct?
Yes, I did.
And you noticed some issues that were going on with the winery at this time.
Yes, I did.
And after this inspection, you placed Peony Estates on probation, correct?
Yes, I did. I told them, yes, go on probation.
However, despite all of these actions and all of these inspections that you have had, you never once shut down Peony Estates.
Well, I never got the opportunity to, because I never did that surprise inspection, right? So what probation is that you go for 45 days, you put them on probation, you go 45 days, I have to do a surprise inspection. And after that, I shut them down. So I never got to do that surprise inspection.
No further questions for this witness, Your Honor.
Redirect.
No redirect, Your Honor. May the witness be excused?
The witness may be excused. You may call your next witness.
The plaintiff would like to call Dr. Jiminy Kwan to the stand.
Yes, can you see me?
Okay. Can you please state your name for the court?
Yes, my name is Dr. Jimin Kwan.
And what's your educational background, Dr. Kwan?
Well, I received my bachelor's in science and biology with a minor in chemistry at the Georgia Institute of Technology. I later went to medical school and got a medical degree at the University of North Carolina at Chapel Hill. And later I did my residency at Emory's Department of Emergency Medicine, where I had the privilege and honor of working under the late legendary Dr. G.T. Seaver.
And what do you do and what's your occupation, Dr. Kwan?
Well, I'm the chief emergency physician at River Valley Hospital in Midlands.
And what do you do as chief physician?
I'm tasked with quickly and accurately diagnosing my patients. I also lead a team of doctors and nurses to tend to my patients. And in addition to that, I'm in charge of ordering tests, making diagnosis, and deciding on the best treatment for my patients.
You do anything else besides chief physician at River Valley Hospital?
I'm also on the board of directors of Doctors for Organic Solutions, which is an organization that advocates against the use of chemical pesticides.
And does that affect your work decisions?
Absolutely not. When you become a doctor, you take an oath, and I make all my decisions professionally to provide the best treatment.
And what do you specialize in your profession?
My specialization is toxicology.
Do you have any publications?
Yes, I have multiple. My favorite is, "Don't you know that you're toxic? Differential diagnosis in poisoning cases."
How are you involved in today's case?
I was the one who treated and diagnosed Genesis Petrillo when he came into the ER.
And what did you review in preparation for today's case?
I reviewed a number of documents. Some of them were, well, one of them was the affidavit of Angel Rodriguez, 2 toxicology and laboratory reports, the analytical report of the Carroll wine bottle that was conducted by Methyl Labs, and an alcohol impairment chart. And in addition to that, Mr. Petrillo's death certificate.
And did you use any principles and methods?
Yes. In addition to a document analysis, I also ran some tests the day that Mr. Petrillo came into the ER.
And these principles and methods widely accepted in your area?
Yes.
Are these principles and methods reliable enough to be applied?
Yes, they are.
What test did you order?
I ordered an ACH test to test like the levels of enzymes that are found in plasma. With this test, you're able to detect whether the nervous system is failing.
Okay, so let's talk about those conducted tests a little bit later. Now I want to address your first encounter with Genesis Petrillo. When did you first come in contact with Mr. Petrillo?
It was in the early hours of June 8th, 2019.
Who first brought Mr. Petrillo to your attention?
Well, Mr. Petrillo came in with a friend, Genesis Petrillo. I mean, not Genesis Petrillo, Angel Rodriguez, along with EMTs. They seemed kind of intoxicated. That was my first impression of them.
And what were your other initial thoughts when encountering Mr. Petrillo?
Well, when they first came in, because I initially thought they were intoxicated due to them smelling like wine, I got a quick summary from Angel Rodriguez that they had been at this wedding rehearsal, and some of the symptoms that Mr. Petrillo was displaying were nausea, vomiting, and stomach pain, which align with alcohol poisoning.
Did you handle any documentations for Genesis Petrillo's symptoms and results?
Yes.
Would you be able to, did you handle the death certificate, for example, for Mr. Petrillo?
Yes, I did.
Would you be able to recognize his certificate of death if shown?
Yes.
Okay. Would you prove it useful to your testimony?
Yes, I would.
Okay. If my co-counsel could please display which has been pre-admitted per stipulation 3, exhibit 7 on the screen. Okay, can everybody see that well?
I can see it.
Your Honor, you see that?
Yes.
Okay. What is that presented on the screen, Dr. Kwan?
This is the death certificate of Genesis Petrillo.
Is this a fair and accurate copy?
Yes, it is.
Has it been modified in any way?
No, not to my knowledge.
Okay. And at this point, what did you suspect may have caused Mr. Petrillo's symptoms?
I believe it was some ingestion of some toxin other than alcohol. At this point, I arrived that organophosphate was the toxin that was present.
Did any new symptoms arrive for that to happen?
Yes, so some of the symptoms that Mr. Petrillo was displaying that didn't align with an alcohol poisoning test were the contraction of pupils. Whenever I shined the light in Mr. Petrillo's eyes, he was tearing excessively. In addition to that, he had involuntary muscle twitching.
And how does one contract organophosphate poisoning?
Well, there are 3 ways. So you can get it from contact through skin. You can get it by inhaling it or ingesting it, which is what I believe was how he got it, sorry.
And what method of contraction did you conclude for Mr. Petrillo's diagnosis?
I concluded it was ingestion. Petrillo didn't really show any signs of skin contact with any poison. The same with inhalation.
And what made you rule out alcohol poisoning?
Well, like I said, alcohol poisoning, there are certain symptoms that are displayed. And while initially Mr. Petrillo did display those symptoms when he came into the ER, there were some symptoms that just didn't align with that, especially due to his BAC, the blood alcohol content. The blood alcohol content was at 0.16%, which is high, but not high enough to cause severe muscle twitching and lack of motor skills.
Okay, and that's just starting off with the symptoms. So let's go to the actual testing results that I mentioned earlier. Explain this ACH test for us.
So this ACH test tests the levels of this enzyme. If the level of this certain enzyme is low, it indicates that there's a correlation with organophosphate pesticide.
And what are organophosphates?
So organophosphates is basically a fancy word for pesticides. They can be very dangerous to humans and cause your nervous system to fail. So, I mean, it's a deadly poison, basically.
And why test for organophosphates?
Well, while other poisons can cause similar symptoms, only organophosphates are commonly found in pesticides here in Midland. And these pesticides tend to cause pupils to contract, just like Petrillo was displaying.
And with that, what did the HCA test and toxicology report show?
They showed that Mr. Petrillo did in fact have low enzyme levels and that organophosphate was present in the blood.
So ultimately, what is your say on what caused James Petrillo's death?
I can say to a reasonable degree of scientific certainty that Mr. Petrillo ingested wine contaminated with organophosphate or pesticide poisoning on the evening of June 7th, 2019, which is what unfortunately caused his untimely death.
Your Honor, I'll pass on the witness.
Cross-examination.
Yes, Your Honor. May I proceed?
Proceed.
Thank you. Now, Dr. Kwan, you said you were on the board of directors for an organization against pesticides. Is that right?
Yes, that's true.
And you think pesticides are a scourge to the environment?
I do.
And you think that today's case will hopefully affect the outcome of legislation in the future?
Yes.
All right. And you also said earlier that there are different ways that a person can become poisoned.
Yes, that's correct.
And you quickly ruled out two of those ways.
Yes.
And you're familiar with the affidavit of Angel Rodriguez?
Yes,
Actually, Your Honor, asked and answered already. I went through this through my direct.
I'm going to overrule. Proceed.
So is that a yes, Dr. Kwan? You're familiar with the affidavit of Angel Rodriguez?
Yes, it was one of the documents I used to come up with this report.
So you are familiar with the fact that Angel Rodriguez took a sip of this wine?
Yes, but based on my understanding from reading the affidavit, Angel Rodriguez.
Objection, Your Honor. Relevance. What does this Angel Rodriguez drinking the wine have to do with our negligence per se case of Genesis Petrillo drinking the wine?
Defense response.
Yes, Your Honor. As we know, the bar for relevance is very high. If I may proffer, I'm using this line of questioning in order to determine that Angel Rodriguez did in fact come into contact with this wine, and contact is a type of poisoning.
Response, Your Honor.
Respond.
Well, as just the opposing counsel just said, the bar of relevance is very high, and therefore I don't see how this question is relevant since it has to do with a completely different person.
I believe that the defense misstated and meant to say the bar is relatively low. So I'm going to overrule your objection.
Yes, Your Honor. So, Dr. Kwan, would you not agree with me that this would constitute contact with the wine, regardless of whether Angel Rodriguez spit it out or not?
Well, it's some type of some type of contact, but it's not ingestion.
All right. Well, can you reliably explain why Angel Rodriguez did not also suffer from from organophosphate poisoning?
Well, she didn't suffer any of the symptoms that Mr. Genesis Petrillo was displaying when Angel Rodriguez and when Mr. Genesis
Your
Petrillo.
Honor, speculation. Dr. Kwan never conducted any tests for Angel Rodriguez. There's no way for her to know.
Yes, Your Honor. As we do know from Dr. Kwan's reports, Dr. Kwan did come into contact with Angel Rodriguez and did see them throughout the night. As such, Dr. Kwan would know whether Angel Rodriguez would be suffering from symptoms or not.
I'm going to allow the question, overrule your objection, and continue.
So
all right.
When Mr. Petrillo and Angel Rodriguez came into the ER, only Mr. Petrillo was displaying symptoms that correlated with not just alcohol poisoning, but organophosphate poisoning. Angel Rodriguez wasn't displaying any of the symptoms, which is why Angel Rodriguez was never admitted into the hospital.
All right, Dr. Kwan, let's talk about your tests. And you ordered a blood test at 02:58.
Objection.
Yes?
Your Honor, I would like to bring your attention that the opposing counsel has ran out of time on their cross.
Timekeepers.
Your Honor, I still have 43 seconds on my clock.
Okay, defense can continue for 43 seconds.
Your Honor, I am taking time for both sides and they are at 0 seconds.
Okay. I'm going to go ahead and end it then, just because I actually don't know what to do with regards to a conflict between the timekeepers. I'm going to.
Could we meet for briefly just to go over our numbers?
Yes, absolutely.
Thank you.
Your Honor, during this time, can I ask my witness to step down, or what do you prefer?
I assume this isn't going to take very long. The witness can step down if they want to, but I'm going to call the coordinator real quick.
So the timekeeper for plaintiff, could you say how much time you had when we started the direct?
In your cross, you had 14 minutes.
No. Sorry, I mean when we started this one, just for Dr. Kwan's cross.
I'm not sure, but I'm going down from the timer.
Okay, so I had 2:57 at the start of this cross, and I also stopped it for objections. I'm not sure if you did the same.
Yes, I stopped for every objection.
I'm gonna, before I begin, if the tournament coordinator disagrees with me on this, I believe that whichever timekeeper has proof of each time specifically and how much time was used is the one we follow. Timekeepers are supposed to follow each timekeeping based on how many minutes each witness had taken, not just going simply down a timer in case of some sort of issues come up like this.
For Kwan, at the beginning of it, they had 3:55.
Okay, there we go. We still have discrepancy.
Yeah, there's still a discrepancy because if you still had 3:55, you'd still have time left over since I started with 2:57 and we still have 40 seconds left.
All right, so I understand there's a dispute on time remaining. So where, and I hope the timekeepers have been confirmed, where does the dispute seem to be? Where did the time go wrong?
Well, for our cross examination, once we finished both the first and second crosses, we had 2 minutes and 57 seconds left for the third cross. The plaintiff timekeeper stated that she had 3 minutes and 55 seconds for the last cross.
Do we know what happened after the first cross exam? So like, I'm trying to figure out, did we lose time in the second cross and the first cross. That'll help me make a decision.
So in the second witness, they lost time in bringing up the exhibit, and I only stopped for objections.
All right, so can someone explain that to me a little more?
I did as well. That still kind of just doesn't explain why she had more time than me and still is stated that the time ran out.
All right. So let me ask the cross-examining attorney, quite frankly, how much time is left in the cross?
Oh, if I was just going off based on the questions I have left, I would say roughly 40 to 50 seconds.
Okay. I mean, obviously, I haven't been here the whole round, and I can't tell when you did or did not stop. So what we're going to do is we'll split the difference. We'll give 30 seconds, and you can have 30 seconds to finish the cross. After that, you are done. 30 seconds, that's what you're going to get. It'll start once I leave and the judge tells you that you can resume your cross. Okay?
Yes, sir.
All right. Thank you.
Okay, you can proceed.
All right. Dr. Kwan, you ordered a blood test at 0258.
Yes.
And this BAC was 0.16.
Yes, it was.
Objection, repetition, asked and answer. I already went through this through my direct examination.
I'm going to overrule the objection.
And Dr. Kwan, you know that Genesis stopped drinking after 12:42 a.m.
Yes, I did.
And BAC would have spiked after that.
Objection, Your Honor, speculation. Again, without testing, there's no way for her to know exactly.
I overrule your objection.
Can you repeat your question? I'm sorry.
Genesis's BAC would have spiked after that time.
After she drank the wine?
Your Honor,
Yes.
they have run out of time again.
Plaintiff, any redirect?
Your Honor, is it possible to object to stalling? I didn't know if that's a rule in any way.
I don't think it is.
Okay,
and I believe that they're supposed to pause the time for objections.
All right.
No redirect at this time, Your Honor. May my witness please step down?
The witness may be excused.
At this time, the plaintiff rests this case in chief, and we just ask for a recess before the defense case in chief.
We're going to have a 5-minute recess.
Yes, Your Honor.
Is the defense ready to continue?
Yes, Your Honor.
Plaintiff, are you ready?
Yes, Your Honor.
Okay, defense, call your first witness.
Yes, Your Honor. At this time, the defense would like to call their first witness, Danny Francasio, to the stand.
You may proceed whenever you're ready.
Yes, Your Honor. Can you please introduce yourself to the court?
My name is Danny Francasio. I am an Italian immigrant, and I am the current head of the Francasio family business, the Rosie and Pedro Winery.
Now, Mr. Francasio, what are some things that you do at your winery?
As an owner of a winery, the first and foremost thing we do is sell wine. Great wine. Wine with grapes imported from France, Italy, everywhere. And the second thing we do is host events. We do weddings, bar mitzvahs, quinceañeras, anything under the sun. Francasio promises that we'll get it done.
And Mr. Francasio, do you have a group of workers that usually help you out with all these processes at the winery?
Yes, like I told you, this is a family business. We are a family. You tend to have about 6 or 10 family members at any time.
Now, Mr. Francasio, I'd like to direct your attention to when you first met Harper Martini. Mr. Francasio, when did you first meet Harper Martini?
Harper Martini is my cousin-in-law. Her husband, Peony, he was my cousin. So one day, she approached me and said she wanted a job. I was admired by her confidence, so I gave it to her on the spot.
Now, what exactly was Harper's job at the Rosie and Pedro Winery?
Well, when she first arrived, she was just a cellar hand, constantly focusing on the different aspects and making sure our wine was the top perfection. We only sell perfect wine at Francasio. So she was working at the wine cellar, making sure everything was up to order, making sure pesticides, were done safely, filtering, all the good stuff.
Objection, Your Honor. Narrative. They could just break that down a little more for us to understand better.
I'm going to sustain that objection.
Motion to strike, Your Honor.
It's striked. Stricken? It's stricken.
Yes, Your Honor, may I proceed? Now, Mr. Francasio, what exactly did Harper do as a cellar hand specifically?
Well, as a cellar hand, her main job was to make sure everything in the wine cellar was up to perfection. Managing a couple people, making sure all the wine and grapes were at the top perfection, and making sure all pesticides were not put inside the wine.
And how did Harper Martini perform as a cellar hand at your winery?
Fantastic. She knew exactly what she was doing. She was a natural at it, and I was very glad that I hired her.
Objection, Your Honor. Relevance. What does Danny Francasio, supposedly family members' personal relationship and feelings towards the defendant have to do with today's case of negligence per se?
Defense response.
Yes, Your Honor. The first thing I would like to acknowledge is that relevance is a low bar objection. And the second thing I would like to acknowledge, Your Honor, is that the question that we asked specifically was relating to Harper Martini's performance as a cellar hand. There was nothing that indicated anything about a personal relationship within their performance or anything of that matter. And also the performance that they would have as a cellar hand would, if I may proffer, Your Honor, would go on to show that there was a level of experience within the business, and that when Harper was to open up their own business, that they would have the knowledge from being a cellar hand to perform safe precautions and everything within their own company as well. This is completely relevant to negligence per se, as we are here contesting a safety statute.
I'm going to overrule the objection. Defense, proceed.
Yes, Your Honor. Now, Mr. Francasio, did Harper have any other jobs besides being a cellar hand at Rosie and Pedro?
Yes, after her stellar performance for me as a cellar hand, I promoted her to vineyard manager after a couple of departures, is what we're going to call them. After those departures, she became a vineyard manager.
Now, how long was Harper Martini a vineyard manager for the Rosie and Pedro winery?
About 3 years.
And what happened after these 3 years?
Well, I'll never forget the day. The day that Harper Martini broke my heart. I invited her over to dinner. She came over there and made me an offer I couldn't refuse and resigned from a position at my winery to start her own winery.
Your Honor, if I may, can I approach the witness with a question?
No, you may not.
Your Honor, may I proceed?
You may.
Now, Mr. Francasio, has Harper ever reached out to you since resigning from the position in 2015?
Yes, she has on a few occasions, specifically partially to vent sometimes and partially ask for some advice.
And what was the usual method that Harper would reach out to you when they did?
Sometimes in cell phone, though I tended to ignore on there, and a couple times on email.
Now, Mr. Francasio, would you recognize a copy of these emails if I were to show them to you today?
There were several, but if you could show a specific one, yeah, absolutely.
Would you recognize a copy of an email regarding on May 8th, 2019?
Yes, I would. I remember those.
Your Honor, this time may I approach the witness with Exhibit 17 to tender?
Yes.
Now.
Objection, Your Honor. Hearsay. This is personal emails exchanges from Harper Martini and Danny Francasio, and is an out-of-court statement. They're being offered for the matter of the truth.
Response.
Your Honor, if I may be heard, in regards to any emails sent from Harper Martini, per stipulation 7 in today's case, Harper Martini is unavailable to testify as Harper Martini is in a coma. Now, for that, Your Honor, there is a specific criteria that has to be met in order for hearsay statements to be, for exceptions of hearsay to be met when a person is considered unavailable to testify. It's under Rule 804A4, which exempts any hearsay statements for Harper Martini, as Harper is not here to testify due to a medical condition which is identified as a coma, per stipulation 7, Your Honor. And after that, Your Honor, these statements are under Rule 804B3A. They are specifically statements that are against interest. Your Honor, if I may proffer from the exhibit.
You may.
Your Honor, the first exact email that is elicited under Exhibit 17, if we can scroll down on the exhibit. The first elicited email is in relation to a health inspection that happened at Peony Estates, and a health inspection goes directly to Midlands Building Code 12-100, which again are aligned within safety statutes, Your Honor. And under Rule 804B3A, any statements that go into a potential civil liability lawsuit are considered statements against interest and therefore are not considered hearsay, Your Honor, for Harper Martini.
Response.
Your Honor, I believe during our housekeeping, I did not hear anything about stipulation 7 being omitted.
Response.
Your Honor, as we are bringing about stipulations and documents to the court, stipulation 3 was presented. Stipulations were being presented to the court today. Stipulation 7 did grant that Harper Martini was in a coma and would not be able to testify in court today. That therefore, under Rule 804A4, they were classified as to why. 804B3A, they were to classify as to why these statements are exempted from hearsay, Your Honor, per stipulation 7. Again, Your Honor.
Response.
Yes.
I would like to bring your attention to a case law, America's Top Cookie versus the International House of Waffles. Is to say that even though the declarant is testifying, and hearsay objection is still hearsay.
Okay, I'm going to overrule your objection. Defense can continue.
Yes, Your Honor. Now, I'm sorry. Mr. Francasio, what was the first email that was sent to you?
Yeah, it was this one right here. It was marked with help. Apparently, Harper failed an FDA inspection.
And did you respond to this email from Harper Martini?
Yes. Well, I was still very upset by how her betrayal of me several years ago. Casey is still a member of my family. And a man who does not take care of his family is no man at all. So I decided to help him for Casey's sake.
And Mr. Francasio, how did you respond to the email that Harper sent to you?
I said, I'll give sure what did you fail? I'll help you out.
Now, did Harper Martini respond to the email that you sent back to them?
Yes, apparently there were two problems. One, there was apparently a drainage system issue. Apparently there was a nasty clog in there. Apparently there was cleaner, and apparently they needed to get that fixed. But along with that, there was a pesticide storage area issue. Apparently some of the people had not put their items in the correct area, which caused a bit of a hazard.
Objection, Your Honor, narrative. They can just break that down a little bit for us to understand better.
Your Honor, may I respond?
I'm going to overrule the objection. Continue.
Yes, Your Honor. Now, Mr. Francasio, did you respond to this email that was sent to you by Harper Martini?
Yes, I did. So I recommended my cousin Jimmy's Picks Royal Flusher. He's my cousin in Italy. He's got a fantastic flusher, perfect for all my needs, and I recommended that one to him to make sure to take care of that drain. And I, reminded him that, of course, the pesticides are very dangerous and that we need to make sure to keep those pesticide storage in the storage area.
And did Harper Martini respond to that email that you sent?
He acknowledged it and said thank you.
Your Honor, at this time, I have no further questions for this witness and tender them for cross-examination.
Plaintiff, cross.
Yes, Your Honor. Hello there, Mr. Francasio. How you doing?
Well, Genesis Petrillo is dead, so not great.
Okay, well, I'd like to ask you a few questions if that's okay with you.
Sure.
Earlier, you mentioned that Harper Martini came to you during dinner to tell you that she was ready to resign and propose her new Peonia Estates. Is that correct?
Yep, she made me an offer I couldn't refuse and resigned from her position.
Okay. Is your sworn testimony that she came to you during dinner to propose her Peonia Estates and her quitting your job? Is that correct?
She came, maybe not dinner. I mean, I remember she came to me and told me she was resigning. Maybe it was not dinner, maybe it was someone else, but she came to me.
I'm asking for a yes or no. Is that correct or not correct?
I mean, like, is whether or not it was a dinner at an issue?
Well, you testify, so I'll make sure that your testimony is correct. So yes or no?
I mean, if you tell me no, I'll say no.
You gave a statement prior to today's trial, correct?
Yes, I did. And I put in that statement that she came to me and told me she was resigning.
Okay. Your Honor, may I approach the opposing counsel and the witnesses with their witnesses affidavit?
You may.
Okay. If I can have my co-counsel, please bring that up to the screen. Okay, specifically to line 79. And Mr. Francasio, this is your witness affidavit, correct?
I mean, let me see my signature and then maybe I can verify it.
Okay, my counsel, can you please go down to the signature? And this is your signature on the last page, correct, Mr. Francasio?
Yes, it is.
And you had 24 hours to make any changes to it.
Yes, I did.
Is this a fair and accurate copy?
Yes.
Now, if I can go back to line 79, if I could, through 80. Please read silently as I read out loud. Unfortunately, that didn't stop Harper from betraying me. It was January 2015 at the end of Harper's shift that Harper came into my office and broke the news that Harper had taken out a business loan to start up another winery called Peonia Estates. Did I read that correctly, Mr. Francasio?
Yes, after her shift, I invited her to my office for dinner.
Okay, Your Honor, I would like to retrieve the document from the witness.
You may.
a few other questions for you, Mr. Francasio. In order to run a winery, you would have a pretty knowledgeable, you would have to be pretty knowledgeable in the field of fruit fermentation and winery, correct?
Yes.
And was the defendant well trained to handle the responsibilities that came with being a cellar hand?
I mean, honestly, no, she didn't have the, as much as I'd like it. But at the same time, I was admired by confidence, and she exceeded all expectations. It was beautiful.
But she did well enough to, eventually get promoted to a higher responsibility, is that correct?
Absolutely, and she exceeded in those positions too.
Okay, and then once in January 2015, like I mentioned earlier, she decided to start her own business, her own winery.
Yeah, apparently
And
she betrayed my family trust.
And over a year later, in August 2016, the defendant has already started to email you about a pest problem in their own winery.
Yeah, they said she had an issue, and so I gave her some advice.
And today, and do you believe the consumer had the right to know about these issues?
I did. I don't want anyone to get poisoned.
Did you eventually send some advice over to the defendant?
My advice?
Mm-hmm.
Yeah.
And the advice.
In the previous email, I explained some advice to make sure, you get your Jimmy Pixel Royal Flusher and make sure you keep your pesticide in a safe area.
That's great, and thank you for elaborating that. But if you could just keep it simple, the opposing counsel will, if they want you to elaborate, they'll ask you to redirect. Did the defendant ever express they failed the health inspection prior to wedding of Casey Soto and Genesis Trio?
It's possible. If you could show me like a specific exhibit or something, like, then yeah, go ahead.
Okay, we can go ahead and read that. I'll just continue. Did Genesis ever come to you with concern on Peony Estates products?
At one point, yes.
And did you ever present information to Genesis on how to report these concerns?
I told him to go to the FDA, as you do.
So both you and Mr. Pacillo had concerns for the conditions of Peony Estates.
I mean, at one point, yes, based on the email, I gave that advice.
And to your knowledge, at least one of you reported this in one way or another.
I mean, I reported it to like a reporter, but I don't think that ever went anywhere.
Correct. And before Peony Estates was established, you and your business properly trained. Oh, I'm sorry, I also prepared a question. And to your knowledge, after the advice you gave to Harper Martini, would you agree the defendant had the choices to listen to you or not?
I mean, her choice was either close a winery down or not have a winery at all, or to follow my advice. So I don't know what happened after that.
And to your knowledge, did the defendant ever choose to follow your advice?
She said thanks, so I don't really know. I hope she followed them, but I don't know.
So the answer is you wouldn't know.
I said that, yes.
Your Honor, I'll pass on the witness.
Any redirect?
No redirect, Your Honor. I just ask that the witness be allowed to step down.
The witness may be excused.
Yes, Your Honor.
Call your next witness.
Yes, Your Honor. We would like to call Dr. Arcan to the stand. May we proceed?
You may.
Can you please introduce yourself to the court?
Absolutely. My name is Dr. Reese Cannon.
And what is your current occupation?
Well, I'm a consultant with Gardner Consulting Incorporated, but I was previously the chief toxicologist at Massachusetts General Hospital, as well as serving as a professor of toxicology at Midlands Medical School.
And why are you here today?
Well, I was hired by Harper Martini to assess the findings as well as present my analysis, of Dr. Kwan's findings and all that. But as well as that, my employer urged me that I testify here today.
And is there any reason why he urged you to testify?
Well, they said that we might lose a client, but I'm certain that that would not be the case.
All right, let's move on. Can you tell us a bit about your education and background?
Absolutely. I earned my undergraduate degree at The Ohio State University in chemistry. And then I went on to Harvard Medical School, where I earned my MD with an emphasis in toxicology.
And have you ever testified in court before?
I have. I've analyzed the evidence of 35 toxicology, pharmacology, and other medical legal cases, including the one here today. I'm certified as an expert to testify in 6 states.
And is your testimony today based on sufficient facts and data?
Yes, my testimony is based on the review of exhibits 5, 6, 7, 10, and 23, as well as the report of Dr. Kwan and the affidavit of Angel Rodriguez.
And what methods did you use to come to your conclusions today?
Well, in analyzing the evidence available, I applied my knowledge in the field from many years of tenure from both Harvard Medical School and as chief toxicologist. In my profession as a consultant, this is a standard practice.
And did you reliably apply these methods?
Absolutely, I did.
All right. Well, Dr. Cannon, you said you were here to assess the conclusions of Dr. Kwan. Can you tell us a little bit more about that?
Yes, so first I have to say that I cannot agree with scientific certainty that the wine was produced by Harper Martini was the cause of Genesis' death. Further along that line, I cannot conclude with certainty that Genesis Petrillo died from organophosphate poisoning.
And why is that?
There are several other causes of death for Mr. Petrillo that cannot be ruled out based on the evidence I've reviewed. Pardon me.
And what are those causes of death?
Well, there are at least 4 possibilities that I cannot rule out based on my analysis, and those 4 are, hepatic disease, alcohol poisoning, a possible allergic reaction, and other possible contaminants.
I'd like to go through each one of these, if that's all right. What can you tell us about a possible allergic reaction?
Well, the staple symptom of an allergic reaction is respiratory arrest, which was noted as the cause for Petrillo's passing. It's possible that he may have had an allergic reaction to the wine or food that evening.
All right. What about your second cause? Hepatic disease, it was?
Yes. So hepatic disease leads to a failing liver and the failure to break down alcohol. This causes low levels of acetylcholinesterase, which Genesis Petrillo exhibited before his death. Alcohol as well can be a trigger for this disease, leading to the symptoms that we saw that evening.
Was there any information that would lead you to suspect either allergy or hepatic disease?
Well, specifically the symptoms and the lack of checkups that Petrillo had in the years leading up to the wedding. There's a lack of information. But for hepatic disease specifically, it mirrors several of the symptoms that Petrillo had. Nausea and vomiting, constricted pupils, and those low levels again of acetylcholinesterase.
All right, and you mentioned a third possibility, other contaminated foods. What about that one?
Yes, so it's entirely possible that the organophosphates were introduced to Mr. Petrillo's system by something other than the wine. Mr. Petrillo consumed an array of food and drinks that evening, and any of them could have been contaminated.
All right. Well, Dr. Cannon, are you familiar that Dr. Kwan ordered reports that evening?
Yes, there were several reports ordered.
And would you recognize it if I showed it to you today?
Absolutely, I would.
All right, Your Honor, permission to show the witness and opposing counsel what has been previously marked as Exhibit 6, and as per the stipulations in today's case, it has already been pre-admitted into evidence.
Permission granted.
All right, what can you tell us about this test and your thoughts about it?
Well, both wine and organophosphates were found in Mr. Petrillo's stomach, but the results were inconclusive, and it cannot be ruled out that the substance came from another source.
And why were they inconclusive?
Well, the stomach churns its contents, breaking them down over time with acid. It's not possible to conclude with scientific certainty that the wine was the source of the organophosphates. It could have easily been mixed in from the other foods available.
All right. Thank you, Dr. Cannon. And to this point, what are your conclusions?
Well, the truth is that we cannot rule out the possibility that Mr. Petrillo consumed another contaminated food, which would explain the presence of organophosphates.
And you mentioned there was one last possibility, alcohol poisoning, if I am correct. What can you tell us about that one?
Yes, so as Genesis, per Angel's affidavit, had been seen drinking that evening and the evening before, it could be very well that he passed away from alcohol poisoning. The plain truth is that we can't rule out that Mr. Petrillo may have died from drinking too much alcohol the night before the wedding.
And what specifically made you suspect alcohol poisoning?
So Dr. Kwan originally suspected alcohol poisoning as Mr. Petrillo was admitted while showing all of these symptoms. Alcohol poisoning can lead to respiratory arrest, which was the cause of death. But I do have to call into question to this point the observed blood alcohol content.
All right. Would you recognize Dr. Kwan's other test if I showed it to you today?
Absolutely, I would.
Your Honor, permission to show the witness and opposing counsel what has been previously marked as Exhibit 5, and as per the stipulations in today's case, it has already been pre-admitted.
Proceed.
All right, Dr. Cannon, what can you tell us about this blood alcohol content and your doubts about it?
Well, it's important to note that while Mr. Petrillo had a 0.16% blood alcohol content at 2:58 when it was tested at the hospital, blood alcohol content peaks 30 minutes to an hour after consumption and then decreases over time from then on.
And why is time so important when it comes to Genesis Petrillo's blood alcohol content?
Yes, so emergency services were called at 12:42 and blood was drawn at 2:58. This means that Mr. Petrillo had at least 2 hours to reach a peak blood alcohol content and that this blood alcohol content was already falling when they got to the hospital. Mr. Petrillo had a higher blood alcohol content than 0.16% before testing, and it's absolutely possible that he suffered from alcohol poisoning.
All right, Dr. Cannon, would you be able to tell us a little bit more about alcohol poisoning?
I would, for sure.
All right, Your Honor, permission to show the witness and opposing counsel what has been previously marked as Exhibit 23.
Proceed.
Dr. Cannon, do you recognize what I just showed you?
Yes, this is an alcohol impairment chart listing out.
Is it a fair and accurate copy?
Yes, it is.
Has it been changed or altered in any way?
No, it has not.
I now move to enter Exhibit 23 into evidence.
Response? Plaintiff? Plaintiff, do you have any objection to Exhibit 23?
No, Your Honor.
Exhibit number 23 has been admitted.
Dr. Cannon, what can you tell us about Genesis Petrillo's symptoms and how that relates to their blood alcohol content?
Certainly. So here at about the 0.12% to the 0.15% range, we see some symptoms that are consistent with Mr. Petrillo's symptoms that were exhibited on the evening that they passed away. And those symptoms were consistent with someone who had a much higher blood alcohol content in the range of even the highest blood alcohol content here on the chart.
And what about the symptoms surrounding Genesis Petrillo's death?
Yes, so some of these are suspect when you look at this chart here. Her coma, unconsciousness, his coma, unconsciousness, respiratory arrest, when compared with the chart here, combined with the fact that we don't know what Mr. Petrillo's peak blood alcohol content was, it's absolutely possible that his symptoms were a result of that peak. Any doctor in the field can tell you, once alcohol poisoning has been achieved, no decrease in blood alcohol content is going to get rid of it. Treatment is required.
All right, thank you, Dr. Cannon. And can you say for certain whether one of these probable causes resulted in Genesis Petrillo's death?
Well, while there can be no certainties, they cannot be ruled out in light of the medical evidence. There are simply too many unknowns.
All right. Thank you, Dr. Cannon. At this time, I have no further questions. And I now tender this witness for cross-examination.
Cross-examination.
Good evening, Ms. Cannon. You work for Gardner Consulting Incorporated, correct?
I do.
And you came to work in this case after being requested, or your services being requested by the defendant, correct?
Yes, that's true.
And one of Gardner's biggest clients is Detsky Roach and Rodent Killer, the pesticide company. Isn't that correct?
Yes, I believe that's one of their clients.
And isn't it true that the loss of Detsky's business would be incredibly detrimental to the consulting firm?
I believe that may be detrimental to their business, but it didn't affect my trial here, my testimony here in trial today.
Yeah, and Detsky's CEO, Eli Harrison, told you that your participation in this trial would determine whether or not the relationship between Gardner and Detsky would continue, correct?
I think what they said was that it was very important if we wanted to have their business, but it's my job to be impartial here in court today. So.
And you were instructed that in order to preserve the business relationship, that the trial end in favor of the defendant, correct?
That is correct, but still, impartiality is important.
And moving on, you never had access to the body of Genesis Petrillo, correct?
No, and as a consultant, I wouldn't. Plus, he was cremated.
And there was pesticide in Genesis Petrillo's system, correct?
The test does say that.
And you know that all food contents in Petrillo's stomach tested negative for the pesticide, correct?
I believe it was all that appeared to be food contents, but that's inconclusive.
Are you aware that all the other food at the wedding reception tested negative for pesticide?
All of the leftover food tested negative for pesticide.
Yes. And isn't it true that more likely than not, Genesis wasn't poisoned by the other food items at the rehearsal?
Pardon me, did you say more likely than not?
Sorry, I'll rephrase that. Isn't it true? Isn't it true that it's unlikely that Genesis was poisoned by the other food items at the rehearsal?
Unlikely, yes, but not impossible.
And in your report, you stated 4 additional potential causes of death, correct?
I think that was one of those 4, yeah, you just mentioned.
Well, but each of these theories that you stated failed to completely explain the state of Genesis Petrillo upon their death, correct?
That is correct, but they do explain possibilities.
And moving on, the bottle of Cara wine tested positive for pesticide, correct?
Yes, the empty bottle did.
And you stated that it is most likely that the consumption of pesticide resulted in the death of Genesis Petrillo, correct?
I stated that it was, yeah.
And isn't it true that you stated that the most likely cause of death for Genesis Petrillo was respiratory arrest that resulted from the consumption of pesticide?
Most likely, but I don't feel that we can rule out the other possibilities based on the evidence.
Yes, and that Petrillo's death was most likely caused by the consumption of wine produced by Peonia Estates that was contaminated with pesticides.
Perhaps most likely, but again, as I said, we can't rule out the other possibilities, and thus there can be no one conclusion.
Yes, I pass the witness, Your Honor.
Any redirect?
None, Your Honor. We just asked the witness be allowed to step down.
The witness may be excused. Call your next witness.
Your Honor, we would like to call Austin Lewis to the stand. May I proceed, Your Honor?
You may.
Can you please state your name and occupation for the court?
Howdy, my name is Austin Lewis, and I am the head winemaker at Peonia Estates.
And Mr. Lewis, what are your responsibilities as head winemaker?
As head winemaker, I oversee the daily operations as far as the growing, the bottling, the processing, everything down to the individual safety measures and employee safety training.
And how long have you been working with wine, Mr. Lewis?
I have worked with wine for my entire life. My mama was a production manager at another winery, and when I got old enough to do it on my own, I followed in her footsteps and found the same position.
And how did you end up at Peony Estates?
My link was from Harper Martini. Them and I were employees together at Danny Francasio's winery, Rosie and Pedro. We worked together, we became fast friends, and one day they made me an offer and said, hey, if you want to come join with us, well, come on. And so I hopped on board and followed that opportunity.
And have you ever faced any issues as head winemaker of Peony Estates?
Of course, running a business is difficult and you're going to run into problems. The biggest one that faced the whole winery was that we the property butted up right next to the Salview Swamp. So right from day one, we were battling against all manner of little bugs and critters.
And what effect did those pests have on Peony Estates?
The biggest impact of having the bugs was that the threat that it posed to the safety of both our growing areas, because bugs eat grapes and that's no good, and bugs getting in the production facility and thus getting into the product, which again is no good.
And how did you handle this pest problem?
What we tried to do was we tried to start off small, using organic pesticides and the like. However, I tell you these things, these bugs, they just wouldn't go. So we did have to step up to using chemical pesticides, but that really was our last resort because we know that that wasn't the ideal solution.
And did you have any concerns about using chemical pesticides?
Again, yes, anytime you're mixing chemicals with the things that people are going to eat or drink, you want to be really safe, and that's what we try to do. So one of the things that we did was that the property where we grow our grapes on, it's at an incline and has a little flat basin. So, we were worried about the pesticides pooling up in that flat land.
And what did you do to avoid that issue?
Well, we couldn't do much to avoid the issue, just because that would mean we have to rebuild basically the entire growing area. But to avoid the risk and protect the safety of our clientele, we would just rope off the sections of flat land when it got close to harvesting season, and we would collect those grapes separately, and all of them would be discarded.
And what would you say the average amount was discarded?
It was a good amount. It was roughly 20% of our annual crop, which is a lot of money that we could have made by selling that wine, but we value the safety of our employees, our company's reputation, and our clientele more than anything else.
And was any of the wine at Peony Estates ever tested to make sure that this was an adequate plan of action?
Yes, it was. In 2018, FDA Inspector O'Keefe came by. They took a sample of 20 different types of wine, of which the Cara was included. The Cara wine in question today, that batch was included, and they submitted a lab report later on.
And would you recognize this lab report if I were to show it to you today?
Yes, I would be able to.
Your Honor, permission to show my screen and show Exhibit 9, which has been pre-admitted without objection per Stipulation 3.
Permission granted.
Mr. Lewis, what did the results, I'm sorry, do you recognize Exhibit 9?
Yes, I do.
And what do you
I'm sorry, continue.
What do you recognize Exhibit 9 to be?
It's the lab report that Inspector O'Keefe submitted to us based on the quality of those 20 wines that had been sampled.
And is this a fair and accurate report?
Yes, it is.
Has it been changed or altered in any way?
Not to my knowledge.
And does the report state how much the level of isophenous organophosphate was in Peony Estates wine?
Yes, it shows that it was 45 micrograms per liter, but that the FDA max threshold for concern would be anything above 50 microgram per liter. So while it may have been a higher concentration, it was still legally a safe product.
And Mr. Lewis, you talk a lot about safety. Did Peony Estates ever do anything else to uphold safety at Peony Estates?
Of course, all the time. One such example would be that at some point we had received a citation for an improperly stored canister of pesticide. What had happened with that was that it had just been put into the wrong storage shed. So to make it easier on our employees and to avoid things like that happening in the future, I just went ahead and I built a whole brand new shed closer by. That way people could leave them there. And I was not required to, but I just went above and beyond. Also, I went ahead and I distributed signs around the building that reminded people to wash their hands, change their clothes, basic hygiene, things like that.
So did Peonia Estates ever receive any health code violations?
Yes, as I alluded to, over the years, we have unfortunately acquired 3 violations.
And has Peonia Estates ever been closed down due to any of those violations?
No, none of the violations we received were ever serious enough for that kind of action.
And you said that you're committed, that Peonia Estates is committed to safety. Would you say that that commitment was even more so for Casey's wedding?
Absolutely. It's our utmost concern to always be a good and reputable company, making sure that our clientele is going to be safe. And we definitely weren't going to take chances when we're hosting the owner's child's wedding.
And what do you mean by that?
One of the several things that we had done, one of them was that a few days prior to the wedding, we had sprayed down the property again for bugs because, we didn't want anything popping up on us. So we had sprayed down. We did have some extra pesticides left over, but rather than leaving them off to the side or doing something like that, which would have been a risk, we just went through them.
Objection, Your Honor. Narrative response.
Overruled.
And so you said that you disposed of these. Where did you dispose of the extra pesticide, Mr. Lord?
This was in the same dumpster where the bottle of Carawine would later have been found.
Right. Thank you. I have no further questions. We are ready for cross, Your Honor.
Cross-examination.
Yes, Your Honor. Good afternoon, Mr. Lewis. I have a couple of questions based on what you just testified to in your direct examination. You had mentioned that Peonia Estates the vineyards were located on a slope, correct?
Yes, I just said that.
And because of this slope, there was a buildup of pesticides at the bottom of the slope, correct?
Not necessarily that there was, but that there was the concern there could have been.
And due to this concern, you actually roped off the bottom 20% of the grapes and threw them out.
Yes, we did that as a safety precaution in the event of something having happened.
All right. And in 2018, you weren't able to throw away these grapes, were you?
I personally was not there. However, I delegated that responsibility to Harper Martini, who is the owner.
The same Harper Martini that was vehemently against this practice when you first started it, correct?
I wouldn't say vehemently against it as you did. They had some concern over it, but they did agree that it was the best practice.
And because you weren't there, you cannot say with absolute certainty that in 2018, those grapes were actually thrown out, can you?
Of course not. I wasn't there. I cannot say with, my hand on the Bible that did or did not happen. However, I never heard any comments from any of the other workers or anything to that extent.
So that's a yes to my answer?
Yes, I suppose.
All right. And I want to move on to something else you said. As part of your job as head winemaker, part of your job was training the employees, correct?
Yes, of course.
And in 2019, you were inspected by FDA Inspector Riley O'Keefe, correct?
Yes, we were.
And in that inspection, one of the violations that Inspector O'Keefe found was that the employees were not properly aware of proper pesticide usage, correct?
I believe so, yes.
So despite your training, your employees were still not aware?
I believe that it was around that same time that is when my trainings became an annual program.
But that's a yes to my question.
I suppose so, yes.
All right. And after this, Peonia Estates was put on probation, correct?
Yes.
And after you being put on probation, you asked Harper Martini to retrain all of the employees, yes?
Yes. We wanted to make sure that there were no gaps in the system. Sometimes we knew that people would be hired during an in-between period, and we just wanted to make sure.
That's a yes to my question.
Yes, I suppose it would be.
And despite being put on probation, Harper Martini said that you could not retrain your employees, correct?
I believe so, yes.
So just to clarify and make sure that I understand this properly, despite being put on probation, Harper Martini made the choice to deny the retraining of her employees, correct?
I can't remember the details of everything thoroughly, but I believe generally you have the right idea.
All right, no further questions at this time, Your Honor. I pass the witness.
Redirect.
Yes, Your Honor.
Proceed.
Mr. Lewis, even though you were not present for the disposing of the grapes in 2018, was there the same amount of yield that there was in the previous years that you had done this?
Yes, when we did our annual audit, it turned out to be roughly the same quantity.
And did you train your employees annually?
Yes, the trainings, remembering now, we did begin them in 2015, so there was an annual seminar given.
And even though you couldn't train your employees twice in 1 year, did you do other things after asking them to be retrained other than retraining them?
Yes, that goes to the point where I'd mentioned that I'd put up signs
Your
around the
Honor.
facility for hand washing and such.
Your Honor, I'd like to bring your attention to the time clock. They have ran out of time.
Does the defense timekeeper agree?
Yes, Your Honor, I agree. I was just letting the witness finish his statement.
Okay. Well, time's been run out. Was there any redirect?
Yes, I just redirect the witness.
I mean,
A recross?
I meant recross.
No recross, Your Honor.
Okay. The witness may be excused.
Thank you, Your Honor.
Defense, do you have any more witnesses to call?
No, Your Honor. We are ready to move to closing statements.
Okay, we're going to have a 5-minute recess before closing.
Yes, Your Honor.
Is plaintiff ready to proceed with closing arguments?
Yes, Your Honor.
Is defense ready?
Yes, Your Honor. But before we begin with closing statements, I would like to address for the record that according to PERS Special Instruction number 14, witnesses must be able to respond to all cross-examination questions. I believe that there was a violation of Special Instruction 14 during the cross-examination of Dr. Kwan. In this case, there was a couple questions where they were not being elicited to answer questions specifically that would otherwise be allowed on cross-examination.
Response?
I believe that they were unable to respond to cross-examination because defense side ran out of time.
I agree.
Your Honor, this was during the after the coordinator gave us 30 seconds to proceed. We were proceeding to try and ask questions, and they were refusing to respond to proper questions that were done on cross-examination during the time frame.
Well, let me interrupt you for a second. If a judge believes that a witness is stalling, they can take it into account during their scoring. There is no objection to stalling, but I just want to make a note that if myself or the other scoring judge believe that stalling was taking place, we take note of that.
Yes, Your Honor.
Okay, are you ready to proceed with closing?
Yes, Your Honor. Before I begin, I would just like to state that whatever time I do not use in my closing, I would like to reserve for rebuttals. And with that, I'm ready to begin.
You may reserve time for rebuttal.
Yes, Your Honor. May it please the court, choices. We are faced with choices on a daily basis. Genesis Petrillo and Casey Soto faced these choices in the lead up to June 7th of 2019. They had several choices to make. What kind of flower arrangements do they want in their wedding? Where do they want the wedding to be located? It was this last choice of the wedding location that led to the results of why we are here today. Janice and Casey ultimately made the choice to agree with Harper Martini and switch their location to Peony Estates Winery. They had all their festivities there, and they were happy with that. But yet, while they were making these choices for their wedding, Peony Estates were making choices several times as well. Despite being committed to safety, Peony Estates has proven that they several times chose convenience over safety. Ladies and gentlemen of the jury, myself, along with my co-counsel as a plaintiff, bear the burden of proof. Our burden of proof was that of the preponderance of the evidence, or that the facts that we stated are more likely than not true. Just a mere 51% chance, if they are true, you must find Peony Estates liable. And to meet these burden, we had 4 elements to prove. These 4 elements were that the defendant violated a statute, that the statute in question was a safety statute. Third, we had to prove that it was the defendant's acts and omissions that caused the type of harm that the statute was intended to prevent. And fourth, that the plaintiff is a member of the protected class. Now, members of the jury, the defense agreed to 2 of these elements in pretrial. They agreed that the statute in question, Midland Safety Code 12-100, was a safety statute. And they also agreed that the plaintiff, Genesis Petrillo, was a member of the protected class. That left just 2 more elements for us to prove as a plaintiff. The first, that the defendant violated a statute. This was done when we brought forth Inspector Riley Atkins O'Keefe, who inspected Peony Estates on several different occasions between 2015 and 2019. With the 2019 inspection, receiving 4 violations leading to their probation. And third, we met this element when we brought forth Dr. Kwan, who talked of the severe symptoms Genesis Petrillo faced in the hours before his death. Dr. Kwan talked about the involuntary muscle twitching, the slowed pulse, and the slowed respiratory that Genesis Petrillo faced. And Dr. Cannon himself, opposing party's expert, stated that he could not rule out for certain that it was pesticide poisoning that killed Genesis Petrillo. Ladies and gentlemen of the jury, we met all four elements we had to prove to leave Peonia Estates liable for negligence per se. They may be committed to safety, but we've shown on several occasions where they were not, and they made the choice of convenience over safety. And for these reasons, find Peonia Estates liable.
Defense, are you ready?
Yes, Your Honor. Your Honor, opposing counsel and members of the jury, may it please the court. Before I say anything about the case that we have heard today, I want to do nothing more but give my condolences on the behalf of Genesis Petrillo's family. You see, we are here because after Genesis Petrillo supposedly drank a bottle of Carl wine, they experienced what the plaintiff wants you to believe as pesticide poisoning. Now, members of the jury, the plaintiff had four things they had to prove to us today. They had to prove to you that the defendant violated a statute. That is something that we contested in today's case. This statute had to be considered a safety statute. We as the defense did not contest this aspect of the burden. They had to prove to you that the acts were of direct and proximate cause of harm towards Genesis Petrillo. We are contesting that notion. And the fourth one is that Genesis Petrillo was a member of the protected class. And we are not contesting this notion. Now, I think something that is very important that has been echoed throughout this trial today is the aspect of choices. And I agree with opposing counsel that choices are very important. But I think their interpretation of the choices that were made by Peonia Estates has been misconstrued. You see, Peonia Estates has forever been an institution and a winery that thrives on its commitment to safety. Because members of the jury, without safety, you cannot run an efficient winery. And I think there's something else that we need to think about in today's case. Something that we didn't see once in this trial today. And I want you to think about it. Think about the most important thing relating to safety statutes in our trial. And think about why did we not once see this one time? I'm talking about the Midlands Building Code 12-100 itself. Now, we've heard both sides talk about this code. And we talked about Riley Atkins O'Keefe talking about this code and their knowledge of this code. But not once did the plaintiff bring this code to us. Not once did they show this code to us. And I want you to sit and think for a couple seconds about why they didn't show this code today. And I want this question to sit with you like a fine wine. So just take a couple seconds and think about why they didn't show us this code. Did you think of any reason why this code wasn't shown? Members of the jury, I'm pretty sure it's obvious why this code wasn't shown. They didn't want to show a code because they know that there was no violations from this code in the first place. You know what that means, members of the jury? That means that they have failed to meet their burden in today's case. Because if they cannot show you directly what caused this statute to be violated and why this statute was violated, then they have failed to meet their burden. Now, on rebuttal, you may hear opposing counsel try to reference every single incident or every single violation that was made by Peonia Estates. And they may try to bring up this building code. But members of the jury, it's too late for this building code. They may try to bring it up and they may try to connect the dots with us to try to show what was going on in the first place. But it's simple, members of the jury. They did not bring this code out for you to see because they know that Peonia Estates was committed to safety. And an important aspect about that is that this was a choice. Peonia Estates committed to a choice of safety, not money, not profits, not anything else, but safety. Now, we have heard today from multiple witnesses about different choices that were made. Let's walk through these choices. Dr. Kwan had a choice today to elicit whether or not there was more than one reason why Genesis Petrillo experienced the symptoms they did. And they didn't give us this choice. They said it is only pesticide poisoning. But if we looked at Exhibit 23, from what Dr. Cannon presented to us today, from the blood alcohol concentration level charts that was presented to us throughout trial today, there were symptoms that was experienced from Genesis Petrillo that wasn't lining up with pesticide poisoning, but with alcohol poisoning. And another thing that I'd like to acknowledge, members of the jury, is that when we look at everything that happened throughout the course of this trial, we heard everything about these methods that were taken by Harper Martini. And I think it's important we walk through why that's important. Because it was a choice. They chose to find ways to fix their problems. And the last thing we saw, members of the jury, if we go in chronological order, was that Harper reached out to Danny Francasio and made the choice to commit to safety. That's it. Now, as I stated again, they have shown us no building code, and that is because Peonia Estates was committed to safety and did no wrong. Please, members of the jury, do not allow yourselves to be convinced when they try to present this building code to you, or when they try to align these dots with you that they refuse to align in the beginning. Because Peonia Estates was committed to safety. Find Peonia Estates not liable. Thank you.
Rebuttal, Your Honor.
Proceed.
Ladies and gentlemen of the jury, opposing counsel just came up and said that plaintiffs did not meet their burden due to us not meeting the direct and proximate cause. But let me walk you through this direct and proximate cause. You heard from Dr. Kwan and Dr. Cannon that it was the Cara wine that was bottled, that was harvested at Peonia Estates. That was the only food item that tested positive for pesticide poisoning from that day. As for the proximate cause, you heard from Dr. Cannon that it was no other food items had tested positive for pesticide poisoning, aside from the Cara wine. That was, again, harvested, fermented, bottled at Peonia Estates. The same Peonia Estates that was put on probation less than a month before the wedding. less than a month before Genesis Petrio's untimely passing. And ladies and gentlemen of the jury, opposing counsel came up and said multiple times that they were committed to safety. But yet you heard from Austin Lewis, their own witness, that Harper Martini made the choice to refuse to retrain her employees, despite being put on probation, and despite the advice that FDA Inspector Riley Atkins O'Keefe gave. And despite this refusal to retrain the employees, they still went and sprayed Peony Estates and the surrounding land with pesticides days before Genesis Petrio's untimely death. Now, ladies and gentlemen of the jury, where in all of this do we see a commitment to safety? You saw multiple times that they ignored warnings from Inspector Atkins O'Keefe about the safe usage of pesticides. You saw that they refused to train their employees and retrain their employees despite this commitment to safety. Ladies and gentlemen of the jury, you have no choice but to find Peony Estates liable for negligence. Thank you.
Okay, we will now submit our ballots. I'll ask everyone to stay on until everyone has submitted their ballots. And when we do, after we do, we will have some brief comments. I'm going to turn off my video and mute myself while I'm finishing out my ballot.
Yes, Your Honor.
Sorry, my laptop died.
Hey guys. Oh.
Okay, it looks like both of the ballots are in. We only had 2 scoring judges this round. First, good job, everybody. I thought this was a good case. Everybody did pretty well. I do have a few comments, and then I will let Mark provide his comments as soon as I'm done. First of all, I know this came up a couple times with regards to y'all talking about it, but the issue of stalling. And I just wanted, I mentioned this before closing, but as a judge, we are allowed to dock points to a witness if they think that if we believe they are stalling. And believe it or not, when somebody has 30 seconds left and somebody's asking for a question to be repeated, I mean, we're going to see that, okay? Even though there's not a specific rule, there's nothing for you to do other than rely on us to take that into account. As far as the attorney work goes, first of all, I want to say all the witnesses were good. The characterizations were believable. It was very difficult to determine, like 1 through 4 for top witnesses was very difficult for me. Everybody did well. With regards to the attorneys, the big thing that I noticed on a couple of cross-examinations was relying on the word correct at the end of a leading question. It gets very distracting, and you take what is a perfect leading question and then you add the word correct, and I've forgotten what you asked, what the question was. And it wasn't just one person. This happened multiple times throughout the trial, where somebody would say, ask a great leading question, correct, and then correct, and then correct over and over again. My next comment, I don't know if there's a rule that requires it for mock trial, but generally in a real trial, if we've stipulated to the admission of an exhibit and it's already been admitted by the court, we're not going to mention the fact that it was admitted by stipulation every single time. So you would say, I'm showing the witness what has previously been marked as exhibit 5 or has been admitted as exhibit 5, the toxicology report, and you would just go right into it rather than saying it's been previously admitted by stipulation every time. It's just a small distraction. Doesn't make a big deal. It's not like I docked points for anybody for saying that or anything like that. I just wanted to bring it up. And I don't know whether there's a mock trial rule that requires you to say it or not. I just want to point out that you normally would not do that. Mark, any comments?
Yeah, I got a few. Just as a preface to all of this, I'm a 1L and I just got out of mock trial like 6 months ago. So take all of my comments with a grain of salt, or less, because that's probably what they're worth. But there were a few things that I noticed. Overall, great job, especially with the time constraints and with this entirely new medium of doing this. I mean, it's kudos to all of you for doing this activity over Zoom. I'm astounded. A couple of things. I was noticing throughout, I was lacking like a really solid, really organized theme in general. I mean, there were hooks, there were some good words that I could latch onto that helped me link to other things. But as far as like establishing a really solid theme, I was having an issue. There also seemed to be some disagreement as to what elements had or had not been, or what issues had or not been already stipulated to. Things about the elements, things about the availability of witnesses. I mean, those documents, those stipulations, correct me if I'm wrong, but those should already be in court. They don't necessarily have to be brought up in pretrial to be, admitted. So just be aware that if it's a stipulation, it's applicable whenever somebody brings it up. There were some things with objections that I think there was some confusion as to what the wording for instance, asked and answered doesn't necessarily mean that because he asked it in his direct, I can't ask about it in my cross. That's not really what that means. Just review and make sure that when you're making an objection, you have the rule, like you have the rule number, and you understand what the content of that rule is specifically. Other than that, witnesses, I absolutely adored the characters. I loved the accents. You used your characters to the point that you could create not inventions, not outside the scope of the materials, but very, very solid and interesting responses to questions. And I really appreciated that. Credible witnesses who needed to be like professional were so. The character witnesses were witty, and they used it properly to bring attention to the facts and draw my attention. Witnesses in this trial I absolutely adored. Overall, great job, guys.
I completely agree with that. I don't think that there's any. I'm going to check the script just to make sure that there's nothing else. Nope. Thank you, everyone. You can sign off of Zoom.
Thank you.
Thank you.
Judging.
Thank you.
To the,
Thank you for judging.
Thank you all, guys.
Been an honor.
Thank you.
Ooh. I don't feel good.